Good afternoon, everyone, and welcome to the International Data Transfers stage at the Bitkom Privacy Conference. I'm Sabina Cioffu. I'm the head of EU and trade policy at Tech UK over in London. We are the sister organization in the UK, doing very similar things to what Bitkom is doing in Germany, so working on advocacy on tech regulation. And I cover everything international affairs. So it's absolutely fantastic to be here with you this afternoon to talk international data transfers. The super important topic on top of minds of policymakers in Brussels, in Washington, in London, and elsewhere on the planet as people are facing kind of increasing digital trade restrictions and trying to figure out how to make various systems around the world work together when it comes to kind of data flows and data protection standards. So it is great to have you all here. This stage will last for about a couple of hours. We will be starting with a discussion with Professor Markus Helfrich from the University of Munich on the aftermath of Schrems 2. If you don't know what Schrems 2 is, you'll find out in 2 minutes' time. It's basically what has upended the whole European international data transfers regime. And he will run us through what that case is and what it means now. From 2:30 to 3:30, Susanna from Bitkom will be chairing a discussion on the Bitkom project on transfer impact assessment and how to make the international data transfers manageable. And from 3:30 for another half an hour, I will take back over from her and we will discuss with Dr. Paul Voigt from Taylor Wessing about the SECs and the implementation of standard contractual clauses. So we've got 2 full hours ahead of interesting and hopefully new information and an interesting conversation as well. And for that point, I'd like to say before we start that you can use the chat function or raise your hand to let us know if you want to intervene or jump into the conversation. And Markus has very kindly agreed to allow you all to interrupt him as he's presenting. So please do come in and let's make this as interactive as possible. So without further ado, I'll hand over to Markus for his presentation.
So thank you very much, Sabrina. And a warm welcome to all of you either joining or still entering our virtual room or virtual classroom, and I'm like to thank all the Bitkom team just for the marvelous opportunity just to share some thoughts and some ideas together connected with the international data flow or data transfer. So my speech or my part is a little bit to be understood as a kind of warming up for the rest of the afternoon, as you got already introduced to my colleagues, and they might dive a little bit more into detail into some specific aspects of international data flow. So what I just like you to show a little bit more, that let's say as a kind of here's my presentation, as a kind of scenery and setup is a question, and I think the question mark in my title is what really important. So what is the situation after the famous court decision given by the European Court of Justice, Schrems 2, and what is the situation maybe we might face or not? So just to begin, where are we standing right now in general? Well, this empty room is a little bit the picture of a not inactive European Court of Justice, but a silent Court of Justice. Some of us might, let's say, hope that this is a little bit representing the nearer future, but we might not get too early a Schrems 3 decision or something like that. So just to remind us, the Privacy Shield framework had been analyzed and evaluated by the European Court of Justice, and the court said that the Privacy Shield agreement is not sufficient to comply with the, let's say, essential European data protection ideas and data protection law. But within the same court ruling, and this is something we should not forget, the court said that standard contractual clauses in general might be an appropriate mean or an instrument to deal with specific data transfer situation to third countries in general, and not only to the United States. But the court said, okay, in general, this might be an interesting instrument, but in detail, and this is something I would call it a kind of homework, the Court of Justice set up for all of us, is we have to analyze or we have to rethink whether or not there might be, depending on the third country we might deal with, are there potentially additional or supplementary measures necessary just to cope and to deal with the requirements, the privacy requirements abroad. So these supplementary measures, they will play quite an important role later on. So I will get back to that in some minutes. Well, what is the legal situation today? And if you read the newspapers or follow the news feeds, wherever, the situation is a little bit, let's put it that way, fuzzy. So we actually today, we do not have yet an agreement covering the transatlantic data flow and related privacy aspects or related data protection issues. The public discussion is, let's say, not clear, not yet clear. For example, the Washington Post some days ago posted the information that an agreement is close to be finalized, and the immediate reaction from the European side, there is still a lot to discuss and clarify. So maybe we might get a little bit further on within the next few days. As far as I learned this morning, I think the relevant negotiating parties will meet tomorrow or the day after. So maybe there is a kind of, let's say, process in that area. But nevertheless, the question of a transatlantic data transfer agreement only covers an aspect that might lead later on to an adequacy decision. In the meantime, some really important aspect or important step happened, namely the EU Commission issued a new set of, or a new edition of standard contractual clauses on the 4th of June. We will have at this afternoon a more detailed insight in these standard contractual clauses, so please forgive me if I'm just putting that in a small nutshell. It includes, or it covers 4 models and different constellations of data export and import, roles of the participants, and related obligations. So this is, although it seems to be direct reaction to the Schrems 2 decision, it's not only, let's say, asked by the court to have new standard contractual clauses. The standard contractual clauses, there was a strong need for a modernization of these clauses, because the still valid or still existing clauses, they date back to the year 2010. And as you all know, 2001 to 2010, we have around about 11 years. So this is quite a long time for transatlantic data transfer. Something of higher importance or practical relevance is the paper the European Data Protection Board reissued on the 18th of June this year. So they published last year the first edition of their recommendations covering measures we should take whenever we think about transnational transatlantic data flow. And now the EDPP did directly refer to the Schrems decision, and therefore the recommendations, they are, I think, from the practical point of view, the most important paper just for our days this year. So I'll get back to that later on. So, what is the question, or what should we think about a little bit more in seriously? So on one side, we do have, let's say, the activities issued by the European institutions. On the other side, there is the question, what's the reality in the application of data protection situation? So first of all, we do find quite an enormous number of recommendations, statements, verdicts as well, dealing with the question whether or not it might be legally possible to transfer data to US or other third countries, and so on. Unfortunately, not all of these statements given either by supervising authorities, by, let's say, interest groups dealing with data protection or business interests in general, or maybe legal experts. They are not always, let's say, well balanced or differentiated enough, and not all of them are clarifying clearly enough the core issues about the topic. So in public or in companies or in industry, there is the feeling that we are today existing and working on an insecure basis, because we do not know, are we allowed to transfer data to yes or not, or under which conditions? So the problem we have is the point is, for me, just to make complicated things a little bit more clearer. Because one impression I got the last weeks and months is that almost everybody is looking for a simple solution, a quick and easy solution, but the problem itself is quite complex. So it's far more complex than simple solutions might allow. So what is the consequence? The consequence might be that even a new transatlantic agreement on data flow will or should not be seen as the holy grail of international data transfer. We have to have a closer look at such an agreement, and I think if we put all the things a little bit the other way around, we might learn that we have we should do something. First of all, we should accept that the European Court of Justice, in both decisions, the Schrems 1 and the Schrems 2 decision, based its argumentation on the finding that both US and EU do govern the way how they deal with data protection, is to be seen on different cultural approaches. So, and both cultural approaches are in some way not really compatible with each other. And this is something we just have to accept, that there are differences, and the problem we have to solve is how to bridge that gap. Not to forget, and that's, I think, one of the leading arguments or aspects we find in the Schrems 2 decision, is that the question how the rule of law has to be considered if aspects of national interests are affected is maybe differently seen if we take the US perspective or the EU perspective. So this makes things a little bit more complicated. Second, we have to realize that the European Court of Justice did not close the door for a free flow of information or free flow of data to third countries. He did set up some, let's say, additional requirements. We have to, sorry, this is, I think, a problem with my PowerPoint now. He gave us a hint that the existing standard contractual clauses of 2010 should be re-evaluated. And this had been done by the EU Commission while issuing the new version or the updated version of the standard contractual clauses in June this year. Second is, or the next point is, that the European Court of Justice pointed at the aspect that there might not be a simple solution for a complex problem. This is, I think, indirectly expressed by maybe a kind of obiter dictum of the court, because he said, okay, well, if we take the standard contractual clauses, we as a court, we are not in a position to say those standard clauses are not an appropriate mean, not an appropriate tool. This is up to the supervisory authorities. They should analyze the situation country by country and case by case, and then make up their mind if there are additional supplementary measures necessary. And this is a kind of homework the European Court of Justice gave to all of us. Yeah, we have to evaluate the relevant risk. And this is maybe something where the European Court of Justice went a little bit further than the GDPR asked us since 2018. Or maybe he made something or expressed something more precisely. Because sorry, again, this is unfortunately not the thing how they should go. So now 3.3 is we have to realize that even if we have a new adequacy decision, yeah, according to the GDPR, maybe an adequacy decision based on a new transatlantic agreement, this adequacy decision as well as the transatlantic agreement will have to take into consideration a risk-based approach. And I think this is the result of that Schrems 2 decision. Because the question whether or not supplementary measures are necessary or are needed to have a proper data transfer to, for example, US, depends on the question or depends on the outcome of such a risk assessment. Well, now it's up to us, and that's, I think, something we have to accept, because we have to learn now as practitioners, as the industry who is depending on data flow to US, for example. We have to learn how to assess a risk and how to analyze that in a proper way. Now the EDPP recommendations are of high importance for that. And let me have really a short look in these recommendations. The EDPP, the European Data Protection Board, does set up a kind of, let's say, 6-step concept or model. First, he says, we have to know our transfers. So we have to be aware which data is transferred to whom, what is the real role model standing behind that, and which processing steps are done within that transfer. Second, we have to be aware on which legal basis we do transfer the data. The EDPP talks about or says talks about transfer tools. This is not meant a software or an app. It's just the tool, adequacy decisions, standard contractual clauses, binding corporate rules. So all the instruments the GDPR offers itself in Article 44 and following. So this is indeed already today needed just to verify let's say the appropriate transfer tool and to fulfill all the requirements hidden in that tool or linked with that tool. Then the third step, this is the risk assessment. Yeah, so we have to assess the risk if there is anything as well in the law as in practice at the third country that may impinge the effectiveness of the appropriate safeguards, so the guarantees we give. The legislation in the third country has to be taken into account first, and then potential practices being incompatible with the commitments of the transfer tool. For example, SCC, the standard contractual clauses. The new standard contractual clauses, they do discuss such situations because they cover an own chapter dealing with, let's say, public requirements or requirements by public administration of transferring data or disclosing data. The next step is we have to identify if the data that is transferred and or in addition to that, the importer do fall under, let's call it problematic legislation of the third country. Yeah. So not every data might be subject to such investigations in a third country and so on. Based on that third step, we have to identify and adopt supplementary measures. So if there is no risk, no supplementary measures are needed. But if there is a risk, we have to think about the supplementary measures. Next slide, I'll show you I'll name some ideas in that. Fifth, if necessary, we have to fulfill the formal steps combined or linked with the transfer tool. For example, if my binding corporate rules have to take into account a specific situation in a third country, then we have to implement these supplementary measures within these binding corporate rules. But the binding corporate rules, they only develop their, let's say, the effect if they are, let's say, agreed by the supervisory authority. So we have to not to forget to fulfill all these formal steps as well. And last step, we have to re-evaluate at an appropriate interval our measures. Are they still appropriate? Are they still necessary? Or maybe are there additional supplementary measures necessary? So what all this shows, these 6 steps, it's a process. It's an ongoing process and nothing to have we might fix right now and then forget that process for the future. Well, just to remind that, step 3, the risk assessment. Yeah. Again, we have to analyze carefully the local law and the practice, both of them. And as a consequence, for example, the EU-located companies have to evaluate their own structure of data processing and to analyze this data processing and the data flow to US, for example, if they do fall under US Cloud Act, under FISA Act, or under the Executive Order 12333. Yeah, so it's not always the case that, for example, my data, which I like to be processed or get processed in the US, might be subject to the Executive Order 12333 or FISA Act. Yeah, so we have to identify that properly. If such an effect is identified, again, the result is not that the data flow is forbidden at all. It requires supplementary measures to be taken. That's our step 4 we already learned some seconds ago. For example, EU-located processor has to rethink about data separation, so splitting databases, if possible, or if it's an appropriate, might be an appropriate measure. But cryptographic methods as well, yeah, technologies that encrypt data, so that I am able, as a European-based company, to decrypt the data. But, for example, under Cloud Act, my American partner, the company who processes the data itself, is not able to decrypt them because they do not have access to the relevant keys. Or, the question how to anonymize, for example, data and so on. So the thinking is that we should handle privacy matters, personal data, in the same way like we might handle, let's say, inventions, technological assets, or maybe papers dealing with future business concepts and so on. I think it's obvious for us that they should not be disclosed to any third party. So this is a similar approach that is connected with the idea of risk assessment within the GDPR context. Okay, let's summarize that for a short, let's say, warming up round. The initial question had been, do we have to face the risk? Yes, I think so. We do have to face the risk. But facing the risk is not to be interpreted or understood as waiting for a new international agreement or adequacy decision. It's not wait and see. It's just, act and see what happens. So this is, I think, an important aspect. Because even if such an adequacy decision, complicated words on this afternoon, might help us, in short, maybe, to run our data flow on a simplified basis. But the danger is quite high that the European Court of Justice, within a future ruling, call it Schrems 3 or whatever, might annulate such an adequate decision immediately if the adequacy decision does not recognize the fact that a proper risk assessment is a precondition for privacy compliant data processing. And this is, I think, the core finding of the Schrems 2 ruling. So risk assessment is a precondition. This is really important for our practice. So as maybe one might summarize that in some, let's say, buzzwords, is our digital business gets more complex, the time for simple legal solutions seems to be over. I'm deeply convinced that we have in future to think a little bit more around the corner, a little bit more in detail, a little bit more carefully and seriously about the problems we have to solve. So things that are different have to be treated differently. And this is, I think, the same underline under the Schrems 2 ruling. And this means the deeper meaning of the Schrems 2 is have a closer look at what you're doing. And I think the result of the Schrems 2 ruling and the activities exercised by the EU Commission and the European Data Protection Board, I think they are sufficiently, or sufficient basis for an optimistic position, because the digital future is ours, but we have to work on it and not, let's say, institutions, a legislator who is traditionally slower than companies, slower than business models might ask for. So if I should, let's say, reduce my speech to one thing or to one sentence is, if things should be good or should be better done, it's up to us to do it better. So this is what I just like to let's say, show you as an introduction. I'm open for questions or critical remarks, of course, and hope that some aspects that I couldn't touch within these 25 minutes are touched by my colleagues later on. Thank you very much.
Thank you so much, Marcus. I'm aware of time and I do want to kind of pass on to Susanna slowly, but just one thought that I had, and maybe you have a reaction to that as you were going through all those steps of the risk assessment and, you know, the idea that companies shouldn't necessarily rely on adequacy agreements, international agreements, which may be struck down by the court, which we've kind of seen in recent years. All I could think about is, you know, kind of look at all of that through the eyes of a small company somewhere in the Czech Republic, trying to figure out how on earth to kind of grow and scale and, you know, grow into international markets. And all I could see is huge amounts of red tape. So is there, like, you know, I think one question is, like, you know, what is the role then of the adequacy agreements and how do, because in the end, you know, that's what makes it easier for companies to operate and it makes it easier for SMEs. And then a second question for the larger companies, is there a risk of de facto data localization? Because this is a nightmare. So then, you know, they just separate it, they stick it into Europe for European citizen and deal with the rest of the world separately. So, you know, just a kind of afterthought after going through all your detailed steps there.
Well, just one short answer to your first question, the small and middle-sized enterprises. I think one important step is just to take seriously the standard contractual clauses, let's say, solution. Because, okay, they are quite complicated to read. So I would prefer to have a kind of synopsis of the different modules. Yeah? And I think there are still already some let's say, easier reading versions of the standard contractual clauses 21 available. But nevertheless, they offer for, I think, most of the situations an appropriate module or an appropriate way to go. So this should not be too complicated, and it's especially for consultants, it's maybe a way just to explain the inner structure a little bit more easy. The rest of the, let's say, the risk assessment is a question when I, as a company, have to process, let's say, critical data that might be of subject or of interest for, let's say, foreign let's say, secret services or of relevance for national security. But to be serious, most of our information is not of high interest for national security. So if Amazon sells a book, that's normally not of high interest. Something different if I do research in, let's say, chemical production or whatever, that might be different. So we have to identify ourselves, what are we doing and what is the character of our work. But this question is not a completely new question. We do have a similar situation whenever we look at, let's say, export control or international security and things like that. So our, let's say, foreign trade relations as a company has to take these aspects as well into account. So there are similarities between data protection and the risk assessment in the third country and the question, what do we export? And now we are not exporting, let's say, machines, we are exporting information. And so this again should be an approach making a little bit easier for even for smaller companies to deal with their specific risk. In general, I think the normal risk should be manageable and not be subject to extremely expensive legal advice or things like that. Your second question is directing at a, let's say, more economic question. Is there a risk that companies shift their focuses outside the European Union and move there just to avoid a little bit the involvement of the GDPR? I think that I don't think that this is a realistic situation, because whenever I've got my core market, at least as well in the European Union, I have to deal with the European data protection rules. So restructuring my business activities might not solve that problem.
Thanks, Marcus. Yeah, I was more referring to, companies separating data and then localizing European citizens' data in Europe, and then dealing with the rest of the world separately, as opposed to kind of using the whole European data transfers regime. Thank you so much. I thought that was really interesting. Probably a lot more questions being asked following your presentation, Marcus. There is one question in the chat that I think you just answered, literally just answered. And I'm aware of time, so I will have to kind of pass on to Susanna now to chair the next panel on Bitkom transfer impact assessment, making the international data transfers manageable. So kind of carrying on nicely from what Marcus presented now to a more practical conversation about where do we go from here. And I will be back in an hour with you to discuss SCCs, which again were just launched by Marcus here in conversation. So we'll just pick it up later on.